There was a confession in court today in the RICO conspiracy case against Donald Trump and multiple co-defendants.
In being transparent with the court and to make sure that nobody else gets blamed for what happened, and so that I can go to sleep well tonight, Judge, I did release those videos to one outlet. And on all candor to the court, I need the court to know that.
That was criminal defense lawyer Jonathan Miller admitting that he leaked the videos of the prosecutor's interviews with the 4 Trump co-defendants who have already pleaded guilty. That leak on Monday night provoked today's hearing on an emergency request by the prosecutors for a protective order covering the pretrial discovery evidence in the case. Prosecutors and almost all of the defense attorneys agreed to accept the version of a protective order written by a lawyer defending David Shafer, the former chair of the Georgia Republican Party. Attorney Tom Clyde, representing a group of news organizations, objected to any protective order at all on First Amendment grounds. But Judge Scott McAfee made it clear that he will issue a protective order tomorrow.
Until we decide what's going to be relevant and admissible, this case should be tried, not in the court of public opinion as much as possible, but before a jury and with competent, with evidence that has been vetted and approved. The court has the power to control in the furtherance of justice, the conduct of its officers. And I combine that with the need to keep the jury pool as untainted as possible, the need to keep discovery free flowing in this process so that all parties can be prepared and to prevent pretrial surprise. We've already seen what may happen if a protective order isn't put in place, which is onerous logistical burdens that we're going to have to discuss. And I think a protective order mitigates, if not protects against all those entirely. So again, I'll be looking very closely, Mr. Clyde, at some of the other First Amendment aspects you raised, such as the ceilings to courtroom filings and that sort of thing. But I certainly will be modeling a protective order based on that proposed by Mr. Shafer.
And after that hearing today, District Attorney Fani Willis filed a motion to revoke bail for defendant Harrison Floyd because, according to the prosecution's motion, defendant Floyd has been publicly communicating with co-defendants and witnesses in the case. The prosecution included 15 pages of Harrison Floyd's social media postings and interviews he has done with Trump-supporting outlets. In order to be released on bail, all of the defendants agreed to, quote, not intimidate any person known to him to be a co-defendant or witness in this case, and to, quote, not communicate in any way, directly or indirectly, about the facts of this case with any person known to him or her to be a co-defendant, or, quote, any person known to him or her to be a witness in this case. The prosecution included 17 examples of defendant Floyd publicly communicating directly to Georgia Secretary of State Brad Raffensperger, who is a witness in the case, and Ruby Freeman, a Georgia election worker who is a witness in the case, as well as several public communications with co-defendant Jenna Ellis, who has pleaded guilty, and co-defendant Sidney Powell, who has pleaded guilty. The prosecution's motion says, quote, because of and in response to the defendant's intimidating communications, witness Ruby Freeman has been the subject of renewed threats of violence from third parties. Joining us now is Andrew Weissmann, former FBI general counsel and former chief of the criminal division in the Eastern District of New York. He is the co-host of the MSNBC podcast Prosecuting Donald Trump and a MSNBC legal analyst. Also with us, Gwen Keyes, former district attorney of DeKalb County, Georgia. And Gwen, let me begin with this attempt to revoke bail here on defendant Floyd. I just want to read number 10. This is item number 10 that the prosecution included in their list of things he has posted publicly. This post says, it's over. Georgia Secretary of State needs to call his lawyer. He's about to go through some things, exclamation point. So that is interpreted by the prosecution as a direct threat to a witness in the case, Secretary of State Brad Raffensperger. And what I find so important about this is whatever action the judge takes on this motion is a window into what we might expect this judge to do in attempts to control other defendants like Donald Trump. And Donald Trump, I'm sure, is watching very, very closely what happens to this defendant.
I think you're absolutely right. And again, the prosecutor, D.A. Willis, in this case, is doing everything that she should to protect the integrity of the case as well as the safety of her victims. This is a motion that you may see in any prosecution where you have some type of threats or intimidation. And so I'm not surprised that she filed it. And we'll see what the judge will do. But I do think the judge's decision in this case will be a bellwether for the other 14 defendants.
Andrew Weissman, every single item that the district attorney included in this large package of offenses, according to the terms of the bond, is very clear. They are all very, very clear violations. Now it's just a question of what is the judge going to do about that?
That's right. And it is important to know that the judge does have things that he can do short of remanding the defendant and sending him to jail. I do think, though, that the bigger picture here, when I was reading this, as much as there is very clear evidence of direct or indirect communications and intimidating statements, both of which are prohibited by the terms of bail under which Mr. Floyd was released, is that it largely pales in comparison to what defendant Donald Trump has done in this case and in D.C. Remember, on Monday, there is going to be a Court of Appeals argument just on the gag order, what he can say. But to me, the striking note here was that it was brought with respect to Mr. Floyd, but it's hard to see how you bring it against Mr. Floyd and not against Donald Trump, where the threat and the risk of violence is far greater based on the words that he's used.